scheme first, yes. Right.
Your Honour, this is a straightforward case of default under the express terms of a loan agreement. There are three relevant defaults: failure to procure completion of the project by the 31st of March 2015, failure to satisfy the conditions subsequent, and material adverse effect. Each of these defaults entitled the defendant to cancel and accelerate the loan, which it did by a notice of demand dated 21st of May 2015. The bundle reference for that is volume 13, tab 251. There's no dispute that the claimant did not procure completion of the project by the 31st of March 2015. No dispute that the claimant did not satisfy all of the conditions subsequent. As a result, the claimant relies on arguments of impossibility, waiver, bad faith, and even abuse of rights. None of those arguments withstand scrutiny. Before turning to the defaults, I'm going to deal briefly with some background for context. I'll then deal with the first default, failure to procure completion by the specified date, and Mr. Francis will then address you on the other two defaults.
Okay.
The restatement agreement was entered into on the 28th of September 2014. And the main focus of this hearing will be on what the parties knew or didn't about the anticipated completion date at the time they entered into that agreement, and what happened after the agreement was signed and in the period leading up to cancellation and acceleration of the loan in May 2015. But the wider background to the restatement does provide some context for the issues that arose under it and the parties' actions. That context is relevant in circumstances where there are allegations of bad faith, abuse of rights, and the suggestion that the defendant was driven to cancel the loan by motives other than the defaults that were and are relied upon. And we say, Your Honour, it shows a consistent, the background shows a consistent pattern of behaviour that further undermines the arguments that are being made. Now, the restatement increased the existing facility significantly from 44 million dirhams to 669 million dirhams, an increase of 50%. The reasons for that increase were delays and costs overruns. Your Honour, if I could ask you to take volume 7 of the bundle. Turn to tab 67. This is a report produced by Abu Dhabi National Property Company, dated October 2013, and ADNPC was at this time monitoring the project for the defendant, so assuming the role that was later taken on by EC Harris. And if you turn over the, if you turn to page 1331, you can see a project dashboard. Right up at the top of the project dashboard, you can see that the anticipated budget is already higher than the original budget, which is the same as the facility amount at that time. If we turn on to page 1334, near the top of the page at point 7, under the heading Identified Project Risks, you can see in the first box, top two items refer to unacceptable cost and programme consequences.
Sorry, I'm not seeing that. Oh yes, I see. Yeah, thank you.
And just under that, immediately under that, high cost and programme consequences. And both of those are recorded as being likely and very likely.
Yeah.
Now in the box just underneath, in the first row, number 1, column on the right, under the heading mitigation, in that box you can see reference to major delays being anticipated. And in box number 3 in the left-hand column, extension of time claims not being resolved, leading to unknown time and or cost consequences. If I can ask you just to turn on a couple more pages to 1336.
Yeah.
In the box in the top right of that page, you can see the third paragraph in that box. Currently, the revised contract value in the project is not fixed, and final project costs are not known. And I can ask you, Your Honour, to turn on to tab 71 in the same bundle. This is the NBC report for December 2013. So I can ask you to turn on to page 1349. Again, you see the project dashboard. And at the top, we can see a further increase in the anticipated budget, taking it further away from the approved budget and the then existing facility amounts. This report goes on to repeat the other risks and concerns that we've just looked at in the October report, but I don't propose to take you through that now.
Yeah.
Now, at around this time that EC Harris produced their commercial due diligence report, and that's in the same bundle at tab 74.
Yeah.
And if I can ask you just to turn on to page 1365. We can see about 2/3 of the way down the page under the heading high-level commercial overview. The claimant's forecast budget is recorded as 537 million, so higher than the anticipated budget we've just seen recorded in the ABN NPC report. And EC Harris's estimate was 650 million, with a warning that costs could increase further. MBAD was obviously concerned about this. And if I could ask you to turn on to tab 75 in the same bundle. You can see there's a letter from MBAD to the claimant late December 2013. And we can see that MBAD is concerned about the costs overruns and the sufficiency of the budget to bring the project to completion. MBAD references the claimant's new budget of 537 million that we've just looked at, and states that it was not previously advised of this material change. MBAD wants information and an action plan. And MBAD also records towards in an ultimate paragraph, actually third paragraph from the bottom, that the claimant is currently in default under the facility because the first repayment date has passed and no repayment has been made.
So I'm not seeing that particular passage. Where are you reading?
It's the third paragraph up that starts
Meanwhile.
Please note the availability.
Oh, yes.
First installment date of the subject project term loan
Okay.
facility is currently past, due since 30/11/2013. As a revised version of the E.C. Harris due diligence report in January 2014, and we looked at it, of course, with Mr. Thomas QC a little earlier, but if I could just ask you to turn to tab 79 in the same bundle. Just look at that quickly again.
Yeah.
So on the front page it's issue 2, revision 1, dated 8th of January 2014. I'll ask you to turn to page 1441. And I should note, Your Honour, that this report is largely the same as the previous version, but there are some additions, including the final paragraph of the summary, which reads, "It is stressed that the project is in a very poor state with unresolved commercial claims, an unclear programme, no development budget and an incomplete design." And E.C. Harris go on to comment on the lack of a development budget. Turning over a few pages to 1445. Looking at the section recommended actions. This is an expanded version of the section that also appears in the first iteration of this report. It starts by listing in the box what E.C. Harris identifies the top 5 key issues. And they include the absence of a clear development budget, issues relating to an incomplete design, unresolved claims that will have an impact on progress and leave the full commercial exposure of the project undetermined, and the absence of a project controls environment. And moving down to the bottom of the page, E.C. Harris recommends at point 1 the appointment of a project manager. Over the page at point 2, a full design scope check. At point 3, resolution of contractual and commercial issues. And down at point 7, that the project budget be defined and agreed. There was a note of a meeting that took place on the 23rd of January 2014, and that's at tab 85 of the same bundle. And I wanted to flag this because, Your Honour, we say this indicates a pattern of behaviour. I've already mentioned that the claimant was in default of the unrestated facility at this time, having missed the first repayment date. And if you turn over to page 1482, and looking at the middle paragraph, the second full paragraph on the page, there was a discussion about...
1482 is in a different divider. Am I looking at the wrong divider? 84, did you say?
Sorry, forgive me, 85. And the page number is 1482.
Thank you. Yes.
Now, there's a discussion about the default, and the following is recorded. The client, so the claimant, was grateful to the bank for its patience and support, but claimed that the amendment agreement was signed by them in haste and was not properly reviewed. They claimed that they would have never signed it had they realised that the first instalment was falling due on the 30th of November 2013. There's an internal note there which notes that the relevant agreement was signed in September, and the client had had ample time to revert to the bank with any concerns. Your Honour, if I could ask you to put away bundle 7.
But the amended agreement is the reference to the February
This is a reference to the facility agreement that was in place prior to the restatement agreement, which is the subject matter of this dispute.
So that's the one dated February 2010 or September 2013?
September 2013.
Right, okay. The second amendment, yeah, okay, thank you.
That's right, that's correct.
Right. Yes, sorry, where are you going now?
Bundle 8, please. Tab 89.
Yeah.
A letter from NBAD to the claimant. Looking at the second paragraph, third line down. NBAD writes, our objective is to address the immediate concerns relating to the status of the project, which continues to face significant delay, and the past due payment of 42 million dirhams since the 30th of November 2013. It remains critical for us to understand your action plan with respect to putting the project back on track and settling the past due payments. And the subsequent bullet points refer to concerns about cost overruns, delays with no certain completion date, the fact that there is no independent project manager.
Yeah.
And over the page at 1496, first of all, paragraph, the bank wants to assure the claimant of its continued support for the project, but within a framework of an action plan that includes locked cost and time to completion, appointment of a project manager to expedite the work, and resolution of the pending issues. Your Honour, it's in that context that the restatement agreement was negotiated and entered into. There were a number of concerns, and the restatement agreement was aimed at addressing them. As a result of the cost overruns and escalating budget, the facility was increased significantly. Hill International was appointed as project manager. EC Harris was appointed as project monitoring surveyor. Those appointments were express requirements under the restatement agreement. The date for completion of the project was also agreed for the purposes of the claimant's completion obligation under the facility. But Your Honour, the issues and concerns that led to the restatement agreement were repeated under it. There were further concerns about the budget. There were further delays to construction and completion. The claimant again defaulted on its obligations. In the context of what had gone before, it's unsurprising that the claimant acted in the way it did in cancelling and accelerating the loan. There was a further report, of course, from EC Harris prior to entry into the restatement agreement, and that's the EC Harris development.
I'm sorry, you've lost me. The claimant defaulted in his obligations. In that context, it's unsurprising the claimant cancelled an acceleration. You mean that? Oh, I see. The claimant.
Sorry, it's unsurprising.
The claimant hasn't defaulted in his
Apologies,
obligations.
it's unsurprising. It's unsurprising. That should be it. Unsurprising that the defendant
Right.
acted in the way it did in
Right.
accelerating
Okay.
the loan. Apologies. Thank you for
Yeah.
Now, Your Honour, there was a further report from EC Harris prior to entry into the restatement agreement, and that's the EC Harris Development Budget Report from April 2014. Again, we looked at that document with Mr. Thomas Pjsc earlier, and it's in the same volume, so volume 8 at tab 108.
Yeah.
It's obviously an important document. First, as with the earlier EC Harris reports, it estimates the development budget to completion and to assist in determining the project's additional funding requirements at this stage. Again, we looked at this with Mr. Thomas QC, but we can see that the development budget on the claimant side is at 589 million, and the EC Harris estimate is 650 million. And we know obviously that the total facility under the restatement agreement was agreed a little bit over the EC Harris estimate at 669 million. Second, EC Harris reviewed and commented on the latest programme issued by Intermas on the 10th of April 2014. And they do that on page 1635 under the heading Observations. That's the important bullet point there is the second one. And again, we looked at that with Mr. Thomas QC earlier, so I won't read it again. But the overall conclusion is that EC Harris think Intermas's programme might be optimistic, but not overly so. The completion date that's agreed between the parties for the purposes of the claimant's obligations in the restatement agreement is 31st March 2015. And that date, certainly on the defendant's case, is based on what we have just looked at there in the EC Harris report, that second bullet point on page 1635. And Your Honour, that brings me to the first default, the claimant's failure to procure completion by the 31st of March 2015. The starting point is that this is what the parties agreed. And as such, the obligation and the consequences that flow from a failure to comply with it should be upheld. A number of arguments are raised by the claimant as to why that shouldn't be the case. We've addressed those in the pleadings and the skeleton, but let me add briefly to some of them by reference to the evidence. Now, it's argued that the defendant knew when the restatement agreement was signed that the obligation was impossible to achieve. The claimant therefore argues that any cancellation of the loan based on that default is in bad faith or an abuse of rights. And we don't accept that the evidence shows that completion by the 31st of March 2015 was impossible by the date of the restatement agreement. Even if it was, NBAD did not know that. The bank did not know that. In early July 2014, EC Harris was, with the claimant's agreement, appointed by the defendant to monitor the project on behalf of the defendant. Again, we looked at the appointment letter with Mr. Thomas QC, so we don't need to go back to it, but it's volume 8, tab 118. And you'll note that that document was signed by the claimant as well as the other parties. EC Harris's mandate from that point included producing monthly monitoring reports, and again, Mr. Thomas QC drew our attention to that in the appointment letter. The first such report produced by EC Harris covered the month of August 2014, but it was not produced until October 2014. Your Honour, if I could ask you to take bundle 10. And turn to tab 152. Cover email dated 9th of October 2015, by which EC Harris circulates its August 2014 first line of the email that EC Harris is attaching its report, having recently received Hill International's report for the same month. If we turn to page 2082 and the executive summary, we can see in the second sentence that reads, this August report has been issued late due to the late receipt of the Hill International monthly report for August at the end of September. We don't need to turn to it now, but there's an EC Harris email to the bank dated 30th of September 2014 that states that the date of receipt of the Hill International report by EC Harris was the 29th of September 2014. And I'll give you a bundle reference for that, Your Honour. It's volume 10, tab 149. So we can see that EC Harris was producing its reports based on Hill International's reports. And the Hill International's report for August 2014 was only provided to EC Harris on the 29th of September, the day after the restatement agreement was signed. The claimant also relies on a briefing paper, or the briefing paper that Hill International prepared in connection with a meeting that was held on the 10th of August 2014. Again, we looked at that with Mr. Thomas QC earlier, but if I could just trouble you to take up bundle 9 so that we can look at it again. Tab 129 in that bundle.
Yeah. On the first page, we're looking at the cover email and the briefing paper that is then behind it, the attachment to the email. Now, looking at the email, we can see that the report was sent to the claimant. Yeah.
We can also see from the text of the email that it has been prepared for the meeting, which will take place in the afternoon.
Yeah.
There's a reference, Your Honour, to hard copies being made available later that morning for the claimant's reference. There's also a reference to the possibility of it being circulated more widely at the meeting in the afternoon. But it's clearly contemplated here that that might not happen. And Your Honour, there's no evidence that it was provided to EC Harris or NBAD.
Yeah.
The claimant also relies on NBAD's approval of utilisation requests in the period June to September 2014 to argue that it must have been obvious to NBAD that progress was insufficient to stand any chance whatsoever of completing the project by the 31st of March 2015. So you can find that at paragraph 23.7 of the particulars of the claim. That argument, Your Honour, does not withstand scrutiny. It is clear that the utilisation requests were not used by NBAD to monitor progress. That is confirmed by NBAD's witnesses, but you only have to look at them and then look at the EC Harris reports to see that. The purpose of the utilisation requests and any review of those requests was to ensure that funds were being properly dispersed under the loan. In summary, Your Honour, there is no evidence that the defendant knew at the time the restatement agreement was signed that completion of the project by the 31st of March 2015 was impossible. Now, the claimant also argues that the defendant knew shortly after the restatement agreement was signed that completion by the 31st of March was impossible. Any cancellation of the loan based on that would also be bad faith or an abuse of rights. Now, that's not really explained anywhere, Your Honour, and in any event, we don't accept it. I should perhaps add here that once NBAD knew that completion was at risk, its first instinct would surely be to keep the project moving, to try to find a solution. That, Your Honour, can hardly be said to be evidence of bad faith. Now, the next point I'd like to deal with is impossibility. And let me deal first with Article 472 of the Civil Code. It's agreed that Article 472 only applies to impossibility that arises after the contract has been entered into. It's also agreed that the impossibility needs to result from extraneous cause in which the obligor, in this case the claimant, played no part. Now, in its skeleton, the claimant relies exclusively on the restriction on Intermass's trade licence to assert that Intermass could not lawfully complete the project. The claimant no longer relies on slow progress caused by Intermass, and that was confirmed again by Mr. Thomas Pjsc in his oral opening. So we don't need to spend any time on that. Now, the key contemporaneous documents you have on this issue are the two near identical letters from Trackies dated the 24th of February and the 20th of April 2015. We won't go through them now, but let me give you the bundle references. It's volume 11, tab 192, and volume 12, 221. What you also have is the claimant's interpretation of those letters, and a letter from the Dubai municipality dated 6th of May 2015, which again we went to with Mr. Thomas QC, and that's volume 13, and the two different translations of that at tabs 231 and 232 of that bundle. And on its face, at least, that letter contradicts the claimant's interpretation of the Trackies letters. The evidence, Your Honour, we say simply does not demonstrate impossibility within the scope of Article 472. Your Honour, there is another more recent letter from Trackies, and that's in volume 15 of the bundle at tab 295. Now this is the letter that...
Sorry, bundle which?
Volume 15.
15.
Yeah.
Okay, that far. Hang on. Here we are.
Yes, volume 15.
Yeah. Tab 295.
Thank you.
This is the letter that the Trackies wrote to the DISC courts. It's dated 30th of January 2017. And what I just wanted to draw your attention to here are the points 2 and 3 in the letter. And point number 2 refers to the issuing all the licenses for consultants and contractors with the sole responsibility of Dubai municipality. And then point number 3 is a reference to the remark placed by Dubai municipality in the contractor license at the reason why I draw that to your attention, sir, is obviously on the claimant side, there's a suggestion, well, this is all about trackies. It's all about trackies. You don't need to have any regard to what the Dubai municipality writes about this. And we say, well, that's far from being clear on the case. Your Honour, just one more letter or document on that, and it's in volume 13. Tab 229A.
Yeah.
And this is a document that we looked at with Mr. Thomas Pjsc. And if I can just ask you to turn on to the second page. That's page 2769.2. So it's a modification permit. And the issue date is the 19th of April 2015. Following down just under the heading project information, about a third of the way down on the page. To the right hand side you'll see that the location of the project that's the subject matter of this permit is the Palm Jumeirah. The reason why I draw that to your attention, sir, is it's suggested that it was impossible for Intermass to obtain any further licences or permits for work from trackies for work on the farm.
Okay.
Now, still on impossibility, let me deal with Article 129 of the Civil Code.
I'll keep an eye on the time.
I am very conscious of the time, Your Honour, and I will be hopefully a few more minutes.
Yeah.
This was a new point raised for the first time in the skeleton. It's not one that was pleaded. Previously, only Article 472 was relied upon, and the introduction of Article 129 appears to be perhaps belated recognition by the claimant that Article 472 only applies to impossibility arising after the contract has been entered into. Now, the suggestion is that if the obligation was impossible, it never formed part of the contract and or never came into existence. Notwithstanding the late introduction of the argument, it's far from clear that that is how Article 129 operates, notwithstanding Thomas Pjsc's reference to the official commentary to a different provision, namely Article 472. But in any event, Your Honour, we're not really sure that this helps the claimant. And if I can ask you to take the restatement agreement, the second volume of the contractual documents bundle.
Yeah.
Turn to Article 20.2, which is on page 1102.
Yep.
You'll see there a representation that the obligations in each transaction document, which includes this agreement, are legal, valid and binding.
I'm so sorry, where are you reading? 20?
I'm reading Article 20.2. It's on page 1102.
Oh, I see, yeah.
Yeah. It's a representation relating to binding obligations. It's a representation of the obligations that in this agreement are legal, valid and binding. Now, if I can just ask you to keep that open and take up volume 11. Tab 174.
This, Your Honour, is an example of a utilisation request that the claimant fills out when it wants the bank to disburse money under the loan.
Yeah.
And this particular utilisation request is dated 6th of December 2014. And each time the claimant submits one of these utilisation requests, down at the bottom at 5B, the claimant confirms that the repeating representations are true and accurate in all the material respects, by reference to the facts and circumstances subsisting as at the date of the utilisation request. If we look back at the restatement agreement under Article 23.3, that's on page 1117. Article 23.3, that any misrepresentation is also an event of default under the restatement agreement. Now, Your Honour, there weren't, I don't think, very many points at all raised by Mr. Thomas QC in his opening that we haven't addressed in our skeleton, but just a couple of notes for the sake of good order. Mr. Thomas QC, towards the end of his opening, was talking about notices or potential notices issued in respect of the completion date default, and he referred to, he was talking about the bank's 18th of March 2015 letter as a first potential notice. And he said there might have been mention orally on the 23rd of March, and I think that should read the 23rd of February. So just to kind of correct that for the record. Again, really for the record, and for the avoidance of doubt, in respect of the arguments on waiver, it's obviously the defendant's position that there was no unequivocal representation or affirmation that would override the waiver provisions in Article 30 of the restatement agreement. That deals with the first default, and Mr. Francis will now address you.
Well, could you just help me a little bit about the construction issue that's raised? Namely that, I think put in its most simplistic form, is that only a default which is capable of remedy falls within Article 23.2 of the agreement.
Yeah. Well, I think there are 2 points raised, Your Honour. One is that if it's not capable of remedy, it doesn't fall within the relevant provision. And of course, you have our submissions on that in the skeleton.
Sorry, it doesn't, i.e., you can't rely on 23.2, or are you saying that if it's not capable of remedy, then it nonetheless constitutes a breach of obligation within the meaning of 23.2, despite the fact it's not remediable? I'm not quite sure what you are saying.
Yeah, that's exactly what we're saying. So we're saying the proper, sensible and commercial interpretation of 23.2 is that if the breach is not capable of remedy, that dispenses with the requirement to give notice.
Right, I understand. So that's That's on its proper construction. That is what you say it means. Yes, I understand. And so you had a second point on it.
And so, sorry, just to give a little bit of context, you know, the alternative interpretation lacks any commercial sense. It would create a situation where the claimant could be in default. The bank would have to be obliged to keep lending, and there would be no obligation on the claimant to complete by any particular date. And this is obviously an important provision, and that would result in it being devoid of any express commercial effect, which in our submission, Your Honour.
Well, I understand the way you put it. Yes, you're saying, well, it really doesn't work if anything, a default which is not remediable is a default which is much more important than a default that is. And that if a irremediable default occurs, I don't know, such as, well, I have to think about it, then it would be surprising commercially to construe this obligation as still requiring notice of remedy. Okay, I understand the point. Thank you. So you had a second point.
I was going to say, really just an additional point is, it is clearly, Your Honour, an after the event technical legal argument, and there's no evidence that either party intended the agreement to operate in the way that is now being argued by the...
Well, I don't think it matters what either party intended. That must be irrelevant, mustn't it?
Intention of the parties is obviously relevant to contractual interpretation under UA law, Your Honour.
Well, that is true. I'd forgotten that. You're quite right.
That it is relevant.
Yeah, we may have to think about that. Understand. Thank you. Yes. Right. Well, let's move on to, if I may,
Your Honour,
20 minutes.
with the best will in the world, I think I'm going to run out of time before I get on to material adverse change, so I wonder if I could hold that over until tomorrow morning.
What over?
My submissions on material adverse change. I'm just doing that.
Well, you just see how you get on. I'm not very keen on keeping it over until the morning.
Okay.
You just got to be a bit flexible. All right. Let's get on with it.
Okay, I'll address you first on conditions subsequent and very briefly on clause 5.3a.
Yeah.
Of the restatement. I mean, in terms of the interpretation of that clause, we very simply say that clause means exactly what it says. It says the borrower shall deliver each of the documents listed in Schedule 2. It also says that those documents need to be in the form and substance satisfactory to the lender. And 5.3b says if any document is not delivered, it will constitute an event of default under the restatement, and no grace period will apply. So we say the claimant simply can't avoid its obligation to provide an amended construction contract.
Simply by saying there isn't one.
Exactly.
I follow that.
Exactly. And the same follows for the assignment of the construction contract as well. In any event, the contemporaneous documents show very clearly that the parties contemplate that the claimant and Intermas would execute an amended construction contract, not just the terms of Schedule 2 of the restatement, but also the parties' correspondence. To save time, I won't take you to all the documents, but I will give you the bundle references. Ms. Shocker emailed Mr. Blow on 14 September 2014, calling for a target date for finalisation or perfection of the amended contract with Intermas. You can find that for your note, volume 9, tab 133. At the bottom of that email, Ms. Shocker refers to a condition subsequent checklist that will be provided to the claimant. That condition precedent and condition subsequent checklist was sent to the claimant, and it highlighted very clearly that the borrower was to provide a amended construction contract and an assignment of the amended construction contract. For your note, you can find that checklist at volume 9, tab 134, and the relevant entries are on page 1833. Now, amendment number 1 was provided by the claimant, but it was only signed by the claimant because Intermass refused to sign it. And the claimant provided this incomplete amendment to the defendant in October 2014, and that's agreed between the parties. It also appears to be common ground that the claimant had long-running price negotiations with Intermass in relation to the amended construction contract, which did not result in any final agreement. That's evidenced by Amendment number 2, which is signed by both the claimant and Intermass. It only concerns the contract price, but the contemporaneous documents indicate that neither party considered Amendment number 2 to be a final agreement on the contract price. That's indicated from the claimant's side by a letter from Hill International dated 2 October 2014. For your notes, Your Honour, that's volume 10, tab 163, page 2258. And that letter from Hill International refers to the claimant's letter of 1st October 2014, which requested advice on whether to sign the contract amendment number 2 or otherwise. And Hill International advised the claimant, I quote, the amount defined in contract amendment number 2 still remains subject to variation by either omission and addition, and in signing the same, DAS are not committed to paying the full amount to Intermass in the event that the aggregate of all such variations results in a lesser contract value. As stated, we can recommend signing said document as soon as practicable. Close quote. There were then subsequent proposed amendments on price that were not agreed between the claimant and Intermass. There was a proposed amendment number 3, which was sent to Intermass by the claimant on 19 November 2014. Note, Your Honour, that's volume 15, tab 298. And a proposed amendment number 4, which was sent to Intermass by the claimant on 7 January 2015. Volume 15, tab 299. Now, the claimant provided the defendant with amendments 3 and 4, so the defendant was well aware that negotiations on price were continuing after amendment number 2. Those negotiations on price between the claimant and Intermass continued up to January 2015 and then reached an impasse. Now, onto the assignment of the construction contract. It's common ground that this was not provided, and similarly, the claimant's argument that they were relieved of this obligation because there was no construction contract, we say is just nonsense. To interpret it in the way that the claimant is now arguing would render this express contractual term in the restatement meaningless. Very quickly, on the contractor's insurances assignment, the claimant accepts that it was not provided, but it says that this was redundant because the defendant was an insured party under the relevant insurance. Now that misstates the actual requirements. The condition subsequent relating to the insurance, note that's on volume 6, tab 45, page 1051, is condition subsequent number 6 in respect of insurances, and it requires that the lender is named as an additional insured and sole loss payee. The insurance contract that Mr. Thomas took you to at volume 9, tab 138 shows very clearly that the defendant is not the sole loss payee. If I can just take you to that very briefly, that's volume 9, tab 138. And it is 1930.2. Top, just under COB, it says endorsements in the name of National Bank of Abu Dhabi, so the defendant, and or DAS Real Estate, the claimant, as principal, and or Intermass, and or Monsieur Al-Wassel Al-Jadid Consultants. So it's quite clear that the defendant is not the sole loss payee under this insurance, thereby the assignment of the contractor's insurance is not a redundant document. If there is any claim under this insurance policy, the Intermass, the claimant, or Al-Wassel Al-Jadid can get ahead of the defendant or can share in the insurance claim. So we say, look, it was important for the claimant to satisfy that obligation before it could satisfy the assignment of the contractor's insurance assignment. I'll address very briefly, you can put away that bundle, Your Honour. I'll address very briefly the claimant's arguments on waiver. The claimant relies upon Article 135 of the UAE Civil Code to say that the defendant was silent, and by that silence it's regarded as acceptance. And Mr Thomas referred to the period of silence being from 28 September 2014, the date of the restatement, to 18 March 2015. We say that simply doesn't reflect the reality. After the restatement was signed, there was no silence. Amendment number 1 was rejected by Intermass on 28 October 2014. Note, sir, that's volume 10, tab 163, page 2247. And a copy of this letter, the Intermass letter dated 28 October 2014, was attached to an email sent by Ms Shocker on 16 November 2014, which is in the same tab. So it shows that the defendant was aware that Intermass had rejected that amendment. Amendment number 2 was the only amendment signed by the parties, and it was provided in October 2014. Amendment number 3 was circulated, unsigned, on 19 November 2014. Amendment number 4, 7th of January 2015, unsigned, or signed just by the claimant. So we say that there is no period of silence here. In respect of the contractor's insurance, again, there is no silence, and I'll take you to volume 10, if I may. Tab 160. Email from Ms Shocker to Mr Blow on 26 October 2014, which is chasing for the all risks insurance with NBAD named as the sole loss payee. So there's no silence on that obligation. In the same volume, in 163, tab 163, and page 2159, see here, Ms Shocker is contacting Intermass directly on 4 November 2014, copied to Mr Blow, saying, to recap our telephone conversation today, appreciate providing the enhanced performance bond and enhanced contractors all risks insurance policy, naming NBAD as the sole loss payee. Then it goes on to say, to enable us to continue meeting the project payments, noting that these are an integral part of the security required by the bank. So again, no silence there. Now we say all outstanding conditions subsequent were referred to by the defendant in 2015. We have the minute of the meeting on 23 February 2015 with the claimant. Now I appreciate that the minute is contested by the claimant, but it is a contemporaneous note, and that refers to the pending conditions subsequent, which constitutes a breach of the restructure agreement. Then you have the defendant's letters in respect of events of default generally from 18 March to 22 April 2015. That's sufficient to put the claimant on notice that there is no waiver of the obligation to satisfy the conditions subsequent. There is also contemporaneous evidence internal to the defendant, which shows that they certainly didn't believe that the obligations of the claimant to satisfy conditions subsequent was waived. If I can take you to the core bundle, volume 2, and tab 28, and then over the page to pages 249 and 250, this is an internal record of the defendant dating from 20 April 2015, which records its own understanding of what conditions subsequent are still yet to be satisfied. You see here, at number 1, a copy of the construction contract amendment duly executed by all parties, and in status, pending finalisation of ongoing negotiations between the borrower and the contractor. Number 2, this is the assignment of the amended construction contract. This records that no assignment was received for the original 2010 construction contract, and the assignment of the new enhanced construction contract is pending finalisation of the same. Number 3, we have the contractor's all risks insurance, and that's noted as not satisfied because NBAD is not the sole loss payee. Sorry, that's item 4.
Yeah.
And number 5, a duly...
First time I picked up the call bundle, I'm not quite sure why we haven't been looking at it before. What's it made up of?
It's an agreed index between the parties.
Right, well that's very helpful. So some of the documents we've been looking at in the, well I hope so, some of the documents we've been looking at and cross-referring to all in the call bundle.
Some of them, sir. Not,
Some of them.
Certainly not all of them.
Right. And do they have the same cross-reference? No.
They don't have the same bundle references.
No. Well, I'll think about that. Okay, thank you.
And then we have the defendant's letter 30 April 2015, which of course expressly refers to the conditions subsequent as events of default. Those are the conditions subsequent which we rely upon in this case. I should add, Mr. Thomas said that we've given up our case on the conditions subsequent in respect of the construction contract, the amended construction contract, and that's obviously not correct. We still rely upon the claimant's failure to satisfy those conditions subsequent. Okay, so we say the chronology of events shows that there was no silence within the meaning of Article 135 of the Civil Code, and the circumstances that are given in the UAE Civil Code, the official commentary, which show what circumstances can amount to consent in where there is silence. So that those are just not comparable to the facts of this case. And then finally, in any event, we rely upon clause 30 of the restatement, which says no failure to exercise nor any delay in exercising any right under the restatement shall operate as a waiver. Yeah. Okay, I'll save my submissions on lack of good faith and unlawful exercise of right for post-hearing closing submissions and address you very quickly on material adverse change. Or perhaps, Your Honour, would it be preferable if I addressed you on that first thing tomorrow morning?
No, I think this is an opening, not a closing. I've got a picture of the issues in this case. It's not the opportunity to go into every argument that you want to pursue in the course of your final submissions. I haven't interrupted. I tried to make sure you were given as much time as possible. But if there are a couple of points you want to make on the issue as to whether there was an adverse impact on certain matters, make them quickly now, or we'll go in the morning. We'll start with the evidence. Okay.
With the material adverse change event of default, the claimant. His primary argument is that, well, we can't rely on that now because we didn't raise it at the time of the notice of demand.
What do you say? That doesn't matter.
Right. So clause 23.13, which is the acceleration provision, does not require the defendant to notify the claimant that is relying upon any specific event of default, and neither does clause 23.11, which is the material adverse change.
I understand that.
No remedy period. So the key question in terms of determining whether or not we can rely upon that provision is in two parts. Did the defendant believe that the claimant's ability to perform material obligations was materially impaired as at the date of the notice of demand? Was that belief reasonable? We've got an abundance of contemporaneous documents which show that the defendant did have increasing concerns about the status of the project and the claimant's ability to satisfy his contractual obligations.
Yes, and we've seen quite a bit of that.
Yes,
We
okay.
have to consider the materiality of it, but I'm certainly aware of it.
I will not take you through the detail of that, but can I just take you to one final document?
Yeah.
Which is Core Bundle 2, tab 36. Mr. Scott's internal email dated 7th of May 2015.
Thank you.
And here Mr Stockon is reporting internally to the
I
group.
think I've seen this document somewhere else.
Mr Thomas,
Slide 36?
Mr Thomas did take you to that also.
Yeah. I have to say, and I won't stop you now, but nothing will be more infuriating, I'm afraid. It is shown two different copies of of the same document in two different bundles. But anyway, let's look at it now. Can I
Bundle reference.
invite people to use the core bundle wherever possible? Although I have to say the numbering system is going to break down. Let me think about that overnight. Yes, I'm sorry. Anyway, the point you're making here is...
Well, he's reporting that the situation has...
Well, he's reporting on the fact that the bank's exposure is very substantial, particularly taking into account the fact that there is a very substantial sum of money needed to complete the project.
Yes, which is well beyond the amount of the loan.
And where's that money going to come from?
Okay, I think we've raced through...
Thank you very much. Very, very helpful. I'm sorry to be a little bit pressing you, but I think it's important to try and keep to our timetable. Right, we will resume at 10 o'clock in the morning. We go on to the evidence, the claimant's evidence, oral evidence, which, as I understand it, we are scheduled to complete by lunchtime, correct? Yes. I hope it's understood. I know that there was some reluctance to use part of our time for some final speeches. Speaking for myself, I'm perfectly content in due course for there to be written final submissions. But I do not really want to leave this oral hearing without having some idea of what the main points that the parties are making in the light of the evidence we've heard. Because that, I think, encourages the party to focus on what matters, and more importantly, it enables the parties to go away and write a final speech which actually takes account of what the other side are actually saying. Okay, well, thank you very much. See you tomorrow. Yes, I would like some help. Would you think about it overnight? What we're going to do with these core bundles? Oh, did I? Lima's put a note in front of me saying that I agreed to sit at 9:30. I wonder who persuaded me to do that. Right, okay, it's 9:30 it is.
But I don't think it's necessary.
You don't think it's necessary? Right, 10 o'clock. I won't let you change your mind. Thank you.